So that was the Truth in Lending Act for credit cards only. So for coerced debt under credit cards. And now we're going to talk about disputing coerced debt, all coerced debt, any coerced debt under debt collection laws. So the first we're going to talk about is the federal law, and then we'll make note of the Texas Debt Collection Act. So the difference between the federal law, the FDCPA, and the Texas law is that the federal law only applies to debt collectors and debt buyers, but not original creditors. So again, just to use the example, if you have a credit card debt with Chase that then is sold off, is, Chase no longer owns it, it was charged off or sold, transferred is what it would appear on the credit report to say, then the new owner may be collecting on it, that debt buyer, or a debt collector on behalf of the new owner may be collecting it through a debt collection calls, texts, emails, letters. This federal law would apply to them. The debt has to be in default when it was sold, transferred, or charged off. A charge off is by definition, it's in default. But if it was sold, for example, an example of this would be an assignee of a loan for an auto loan. So technically, the original creditor on an auto loan is the dealer, but it's immediately transferred to the entity that's financing it. So if it's financed through like Toyota Motor Credit or through Chase or through a credit union, they're the assignee of that contract. So they're not the original creditor, but it wasn't in default when it was transferred. So they're not considered a debt buyer or a debt collector. So the FDCPA would not apply to them. The Texas Debt Collection Act, however, applies to original creditors and debt collectors and debt buyers. It doesn't have to be in default whenever it's transferred or sold. So it applies to everybody, which is great. It's just not as protective as the FDCPA. So the FDCPA, again, which is the federal law, it gives the consumer certain rights. And one of those really strong rights is to stop communication about the debt. So the survivor can request for all communication about the debt to cease, or a particular type, like do not call me, don't text me, don't email me, send me everything in writing by mail, or don't send me anything in writing by mail, only text me or only email me. That's something that's newer under Regulation F that came out a couple of years ago. You used to have to request that information in writing. Now you can request it, whether on the phone or email or text, just saying generally, don't contact me anymore, or, don't contact me through this communication method. Then there also has the right to receive notice of the right to dispute the debt. So this is called the G notice. So in any debt collection attempt, they have to say you have the right to dispute your debt. And then they also have the right to request validation. And that's essentially like an investigation, like the other two statutes that I mentioned, where if you dispute it and request a validation, they have to investigate it for 30 days. They have 30 days to investigate it. The challenge is that the request for validation must be timely. So generally what will happen, it'll be 30 days from the initial date of the date of the initial communication. So if they get called on the phone, they get emailed or text, and that's their very first communication, they'll say you have 30 days to request validation. And then if after that 30 days has passed, you don't have that right anymore, but you still can dispute it. You can dispute it whenever. You don't have to, the dispute can be, the day before you get served a lawsuit. You can dispute it at any point in time. But the validation itself is a little different. It makes they have to provide certain information, like of how the amount of the debt and how it's obtained and all these different things. And then the law also, this is good for those that are defending consumers in debt collection lawsuits. The law says it dictates a venue for collection. So they have to be sued, the consumer has to be sued in the county that they live in, they reside, or where the contract was signed. Those are the only two places. It can't be where the defendant resides. It has to be, I'm sorry, where the plaintiff resides. It has to be where the survivor resides or where the contract was signed. So again, they have the right to dispute the debt based on identity theft. The validation you see here, it has that 30-day deadline. But after that, you can still dispute it. And, again, similar to the other types of statutes we've talked about, I would include a copy of the police report, the FTC report, explaining that this is identity theft, and why, the consumer is not responsible for the debt, shouldn't be held liable, etc. After they've been notified about the fraud, about the identity theft, they can't sell or transfer the debt and can't place it for further collection. That's one of the requirements here. Often they don't comply with this, and that's a separate violation. But that, they can't say, you tell them, I don't know this, identity theft. And they're like, okay, well, we can't collect on this. So now we're going to sell it to someone else. So we're going to make a profit on it, sell it to someone else, when I know that this isn't a collectible debt because of identity theft. There's an overlap of debt collection laws and FCRA, so the reporting. If it, you see down here in red 1692 E8, it's a violation of the statute to provide false credit information. So if the survivor's disputing it, saying it's identity theft, and the debt collector does not report that it's disputed on the credit report, that would be a violation of the statute. So anytime you dispute it, whether it's through this law or through the Fair Credit Reporting Act, it has to say on the credit report, if it's not removed, if it's not blocked, it must at the very bare minimum say that it's disputed by the consumer. So what should be in the FDCPA dispute letter? Again, similar to other dispute letters, why you're disputing it, that you're disputing it, include copy of the police or identity theft report, request validation of the debt, request all documentations pertaining to the alleged debt. You can also request cease collection attempts. So say, in the letter, like, after you provide me the results of my dispute, then you cannot contact me anymore. Please stop calling me. Please stop contacting me. I would advise the consumer to keep a log of all of the calls, the creditors, letters, and all of this information, because it's going to be important for the 521 to list all that information. Again, after receiving that dispute, they have to stop any collection efforts while they investigate it. They can report the debt as in dispute to the reporting agencies, but they can't sell or transfer the debt. So that's kind of a summary of what I just had said before. Now, taking a step back and going to the Texas Debt Collection Act, which has to do with debt collection again, but this law applies to all creditors, all debt buyers, all debt collectors. It's not limited like the FDCPA. It's found in Texas Finance Code Chapter 392. And it includes a list of activities that, creditors and debt collectors cannot do in attempting to collect a debt. It does not provide the cease and desist remedy like the FDCPA or the validation dispute, but it does provide protection from harassment and deceptive practices. So some of those include, as far as like protection from harassment, communicating with third parties other than the survivor themselves, unless they're trying to locate the survivor. So the only reason they could contact someone else is say, hey, they can't tell them that they're collecting a debt or who they are, but they can just say, do you know contact information for a survivor? Is this the survivor? Is this their address? They can't communicate with the survivor if the survivor has a lawyer, or take action, threaten to take action they can't legally take, like threatening criminal arrest, saying we're going to put you in jail if you don't pay. This kind of goes beyond the scope of this presentation, but even though you can't really, they don't have to do the whole investigation and all of that, It's still, again, generally those creditors are going to be covered under, if it's a credit card debt, they're going to be covered under the Truth in Lending Act that we talked about. So you should still dispute with them. And if they're a debt buyer, debt collector, they may be covered under the FDCPA. So you should still dispute with them. So even though the Texas law itself doesn't provide those dispute and investigation remedies, as a best practice, I would go ahead and dispute with any party involved in collecting a debt that's a coerced debt. So here's another scenario that we could go through. So again, James and Maria, this is the same scenario that we've been going through since the beginning. James and Maria were dating. Without her knowledge, James got a new cell phone and started cell phone service for himself using her name because she had good credit. After she left him, she started getting collection calls for cell phone purchase and account she didn't recognize. So what legal remedies does Maria have? And what other questions would you ask? So assuming that you've done all of the screening with her and you've identified that this is an account that resulted from identity theft, whether it was coerced or fraud. And in this scenario, it seems fraud because she wasn't involved with it at all. And it was, through her former partner. Then you would have the identity theft remedies available to everybody under federal and state law. So if it was on her credit report, you would want to ask those questions and pull the report and see if it's on there. So if the collections account is on her credit report, you have the legal remedies of disputing it or requesting a block under the Fair Credit Reporting Act. And then if, because it is a debt collection call that she's getting, if the debt collection is with if the debt collection company started collecting on the debt after it was in default, then you would have the right under the FDCPA to dispute the debt, to request validation, to request cease and desist, if that's what Maria wants to do. So you would have remedies under the FDCPA.